12:30 docket.
I'm ready, Judge. I have Mr. Massuda, and I believe he is in the heat.
All right, Massuda, please.
Brandy Merrifield on behalf of Thomas Massuda in 26 CF 478. Come stand right next to me. Mr. Massuda is present. Judge, we're here today. He was held for pretrial detention based on the nature of the charge under 907-041. I don't believe the state is moving forward with pretrial detention.
That's correct, Your Honor.
And we have discussed the parameters of bond and have reached an agreement as to bond conditions for Mr. Massuda.
All right, what are the terms and conditions the state and the defense have agreed to?
Judge, the dollar amount would be $30,000 cash or professional. He'd be required to have a GPS outfitted prior to his release at the reduced rate of $1 a day. There would be no contact with Courtney Sage, S-A-G-E. No trespass at 17 Pryor Road in Fort Walton Beach. And he would be placed on pretrial services to include weekly in-person check-in. I believe those are all the conditions, Mr. Gomez.
Those are the terms, Your Honor.
All right, standard conditions, weekly reporting in person, no contact, not be within 500 feet, surrender of weapons, firearms, GPS $1 a day, not return to the Pryor Road residence. Any other conditions?
No other conditions from the state, Your Honor.
None known to the defense, Judge.
All right,
Thank you, Your Honor.
thank you.
That's all I have this afternoon.
Just my second.
Okay, you're good. Here, take your paper.
Thank you, Ms. Merrifield.
Thank you.
Good day.
Good morning, Your Honor. Tim Weaver on behalf of Krisby Quichi Jute.
All right.
And he was arrested end of last week, and it's been set for today.
Your Honor, the state is not going to go forward with pretrial detention at this point, but we are asking for a bond with certain conditions.
All right.
We would
Have
ask
you discussed those conditions with Mr. Weaver?
some of them. I had to discuss with victims' family first, confer with them, which I did. So now I can have an answer. One of the conditions that I have not discussed is that if the court sets a bond, the pretrial services be part of the conditions, reporting once a week, and by phone, once a month, in person, GPS monitor, no contact with victim and victim's family, not to be within 500 feet of victim and victim's family. I know he was attending Choctaw High School, so we would ask that he doesn't. And then obviously a bond commensurate with the level of the offense.
Any issue with those pretrial conditions? And then we'll get to the monetary bond.
I'd prefer to not have the GPS monitor, but I know the court does that in these kind of cases. My client's a soccer player, and he's trying to, might be hard to play soccer. I don't know if he's going to even be able to if he gets released. Judge, I would tell the court that there's currently an injunction in place signed by Judge Brown, which prohibits him from, he's a junior at Choctaw, can't go back to Choctaw. He'll have to find some other place to go to school. And no contact, that's already a court order. Of course, I'll explain the injunction to him. Judge, I don't believe he's a risk of flight. I don't believe he's a danger to the community. Very, very small priors. I believe the only thing was a driving license suspended. He goes to church regularly. He's in ROTC. He's, like I say, an athlete and a student, junior in high school. I've got a bunch of letters from different people, but I think that's all we need to do today. The family's not wealthy, Judge, so I know the charge sounds very serious. I don't have all the facts on it yet, but it was a high school relationship that lasted for a few months and culminated in this arrest.
Yes, sir. All right, so what about monetary bond? What sort of bond is the defendant able to make?
Do you know what you can afford for bond? Could the court set a $5,000 bond? He's an 18-year-old young man.
I would ask for 10,000 cash or professional.
10,000 cash or professional. Pretrial services, standard conditions, plus the provisions of weekly reporting by phone, monthly in person, no contact with the victim, not within 500 feet of the victim's residence, and so on. And I understand your arguments about GPS. I've read the addendum of probable cause, and I realize that we're not trying the case today. But it does appear from the addendum of probable cause that there was a significant attraction by the defendant towards the victim, and the defendant engaged in pursuit of the victim. Now, I'm not saying it wasn't mutual, but I don't know anything about that. All I know is about what the addendum of probable cause is.
Yes, sir.
And most good decisions come as a result of experience, as my grandfather used to say, and most experience comes from bad decisions. So this court's experience has been is that given those sets of circumstances, we want to give both the defendant the opportunity to be sure that he's accountable, and the state the opportunity to assure that they're discharging their obligation to the public and making the defendant accountable. And so under those circumstances, I think the GPS is appropriate for that accountability. And so I'll apply the GPS, and I'll do that at $1 a day considering the circumstances presented. Now, as you know, Mr. Weaver, from experience, if the defendant does well and has no violations, and this does obstruct his ability for his education or his other endeavors, then I'll reward good behavior. But at this point in time, I think it's appropriate to assure both the safety of the alleged victim and assure compliance that the GPS is necessary.
Yes, sir.
All right. Any questions?
Could you just clarify, you said that he needs to report, is it weekly by phone or in person, or?
Weekly by phone and monthly in person.
Yes, sir.
Because they'll need to assure a check on the GPS and so on.
Yes, sir.
Okay?
Thank you.
Thank you.
I have one final question, Judge.
Yes, sir.
It's an important matter. My client, he plays in a travel soccer team and plays in Georgia. Is he allowed on pretrial release to travel?
He can make those arrangements with pretrial, and if they have a question, then he does that in writing, and then I'll issue an order which will allow that. They'll explain that he has to provide the itinerary and those sorts of things.
Yes, sir. Thank
All
you.
right? You're welcome.
Thank you.
Next, Your Honor, we have Benjamin Tran.
Judge Jason McKinney on behalf of Benjamin Tran, 26 CF 490. I do not believe that the state is seeking to move forward with pretrial detention in this matter. I'll pass it to Mr. Snell.
That's correct, Your Honor. The state is asking the court to issue a cash or professional bond in the amount of $100,000 for count one, trafficking of fentanyl, $5,000 for both possession of controlled substance counts, $1,500 for the possession of paraphernalia and the trespassing charge for $113,000 cash or professional. And then weekly reporting, Your Honor, for pretrial services.
All right?
Judge, we're not going to object at this time to the court setting a bond. We'll defer to the court and reserve the right to come back on the bond hearing if need be.
All right, so count one, 100, count two,
5,000. Count three would be 5,000. And 4 and 5 would be 1,500 apiece.
all right? So ordered.
Thank you, Judge.
All right. All right, so we'll be in recess.
All rise.
This was set for these were his cases. Okay? He scored 65. He won trial, he was guilty. He wanted to leave the bench. I said, "Ooh, leave the bench, you know the minimum, but the
during lunch from 11 to 2. We hope to
Please be seated. Mr. Koch, you ready with your clients?
Yes, Judge. If I could first call Ms. Jessica Rainey in 26 CF 234. Yes, Your Honor. We'll be entering a not guilty, waive formal reading. Request this be kept on the 511 docket, Judge.
All right, does the state have an offer?
This currently is a 7-year mid-man, Your Honor, offer on the table.
All right.
And additionally, Your Honor, this case had a TR companion ticket associated with the DUI. I'm requesting that the TR ticket be tracked along with our case, if I can provide that TR case, ticket number for Madam Clerk.
Yes, please.
It's going to be Alpha, Sierra, Mike, Delta, Quebec, Oscar, Papa. I have that as a citation number. And there's probably a TR number I should have gave you. Is that correct, Madam Clerk? I apologize.
Yeah, that sounds like the citation number, right?
Yes. Yes, that's correct. We'll approach on that. Judge, if I may approach with Mr. Snell.
Granted.
Sorry. All right, your new court date is actually going to be 7/13. Yep, so 7/13 is the next court date. You know to go downstairs, they're going to get tracked along. Okay? That's everything for my client. Thank you, Judge.
Thank you,
All right.
Judge.
You're free to go.
Thank you.
Yeah, you're welcome. Next, Judge, Ms. Brianne Ponick. Yep, she's present and approaching. 26 CF 310, Your Honor. Thank you, Judge. Just inform the court, currently there's a 2-year probation offer, but due to the nature of the charges, it's a mandatory adjudication of guilt also, Your Honor. Thank you. So we will be entering a not guilty, waive formal reading, and request this be kept on the 511 docket.
So ordered. Stay in touch with your lawyer and be back on 511, okay?
Yes, sir, thank you.
Thank you.
Take that with you. You, good to go. Jason, you want to call?
This is Molly Yeski with the Public Defender's Office covering for Jason McKinney. I just have a few clients to call.
Yes, ma'am.
Mikkel Triplett. Mr. Triplett is approaching. This is in case number 26CF226. We'd like to enter a plea of not guilty, waive formal reading.
All right. Is there an offer from the state?
Yes, sir. I'm getting to my page here. 30 days in the county jail or 2 years of probation.
Standard conditions?
Excuse me, sir.
Standard conditions, any specials?
Just clear anything against his license that he can clear, and, no use of intoxicants. so.
All right. And is that set on 5/11, Madam Clerk?
Yes, Your Honor.
All right. Stay in touch with your lawyer. Be back in court on May 11th, okay?
Yes, sir.
Thank you now. Good day.
Next, I have Gerald Vaughn in 26 CF 269. Also enter a plea of not guilty and waive formal reading.
Do we have an offer in this case, State?
Be an adjudication, 2 years of probation,
I'm sorry, how many years?
2 years of probation.
Any specials?
There would be 50 hours of community service, no consumption of alcohol or controlled substances without a prescription, and random testing for both.
All right. And is that set on 5/11, Madam Clerk?
Yes, Your Honor.
Okay, 5/11. Stay in touch with your lawyer and be back in court on May 11th, okay?
All right, sure will.
Thank you now. Good
All right,
day.
then. Have a good day.
Lastly, Michael Williams, who's approaching, this is in 26 CF 241.
Good afternoon.
Will enter a plea of not guilty and waive formal reading.
Offer from the state?
I have had some conversations with Mr. McKinney, and we're working towards a resolution on this one.
I was wondering,
Okay. And Madam Clerk, is this set for 5/11?
Yes, Your Honor.
All right. Stay in touch with your lawyer. If they reach an agreement, they can bring it back before 5/11, but otherwise you'll need to be back in court on 11 May, okay?
yes, sir.
All right, thank you now.
Thank you.
And I just have one in custody, but you can call it on this.
Mr. Cochran.
Yes, Your Honor, I have a couple. Ms. Nicole Langley, she is present and approaching. Case number 26 CF 0293. Your Honor, we'll acknowledge the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the 5/11 court date.
Does the state have an offer?
Yes, Your Honor, we had offered adjudication of guilt, 6 months in the Okaloosa County Jail, or enroll in the drug court program.
There'll likely be a motion to suppress in this case, Your Honor.
All right, we'll leave it on for 5/11. Stay in touch with your lawyer. Be back on May 11th, okay? Okay.
I have Tyree McCorvey, Your Honor. This is 26 CF 0295. We'll acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the May 11 court date.
Does
And
this-
my offer may have to withdraw. And my office may have to withdraw.
Oh, it's a conflict
I
potential.
believe there is. Yes, sir.
Okay. All right, is there an offer?
There is, Your Honor, as of right now, it's adjudication of guilt, 11 months and 29 days in the Okaloosa County Jail. That would be a downward departure, as the guidelines score sheet shows 17.33 months in the Department of Corrections.
17.33?
Yes, Your Honor.
Now, stay in touch with Mr. Cochran. He's told you that he might withdraw. An order will come saying who your new lawyer is. It's in all likelihood going to be Ms. Jaquit from the Office of Regional Conflict Counsel. If you register your email with the clerk, you'll get a direct notice of that, okay?
Yes, sir.
Okay, thank you.
Next, I have Miss Alyssa Moranta. We acknowledge receipt of the information, Your Honor, waive formal reading, enter a plea of not guilty, and ask to leave this set for the 5/11 court date.
So ordered. Is there an offer?
Yes, Your Honor, it's an adjudication of guilt, credit for time served.
Okay,
There's it is a habitual driving charge, Your Honor, and I want to speak to her about
absolutely.
repercussions of a driving record.
Stay in touch with your attorney. Be back on 11th of May, please. Thank you.
Next, I have Mr. James Musgrove. Then we have Mr. James Musgrove, 26 CF 0196. We acknowledge receipt of a 4-count information, enter a plea of not guilty, waive formal reading, and ask to leave this set for the 5/11 court date.
So ordered. Is there an offer in Mr. Musgrove's case?
Yes, Your Honor, it's adjudication of guilt, 3 years in the Department of Corrections. That would be a mandatory minimum $50,000 fine, so mandatory.
All right. All right. Stay in touch with Mr. Cochran and be back in court on 11 May, okay? Good day.
Call me. Oh, here, this is yours. Next, I have Mr. Devon Nolan, Your Honor. Davion. Case number is 26 CF 0274. Acknowledge receipt of 1-count information, waive formal reading, enter a plea of not guilty, ask to leave this set for the May 11 court date, and there's likely to be a motion to suppress on this.
All right. Is there an offer?
Yes, Your Honor, to withhold 3 years of probation, 48 hours of community service work, forfeit the firearm at issue.
Okay. All right. Stay in touch with your lawyer and be back in court on 11 May. Thank you.
Thank you, Your Honor. That's all I have in the courtroom.
Jennifer Nolan.
She is in custody, Your Honor.
Oh, she is. Okay.
Yes, they had her under, she wasn't transported yesterday because they had her under the wrong name,
Ah,
but
okay.
she's transported today.
And Mr. Koch, you got all your folks?
The rest would be in custody, Your Honor.
Okay.
There are a couple who don't have attorneys,
Yes.
but if possible, I would like to call one inmate. He has family here,
All right. Who is that?
Mr. Robert Taylor. He's
Robert
not-
Taylor, please.
We're not appointed yet, but I anticipate we will be.
Your Honor, I do not see that any information has been filed in this case.
I didn't see it either.
Yeah, no information. Your Honor, you have Mr. Robert Taylor in front of you, case number 26 CF 0231. As I stated, we have not been appointed. I anticipate we will be. So I would ask the court to appoint us at this time.
I'll appoint provisionally until we get an affidavit from the defendant.
Yes, sir. And I'll have him fill that out. I will. He is transient, so I believe he will qualify very easily. Your Honor, this case, this date of arrest is January 30th. At this time, there's no information still has been filed. I would be asking for an ROR bond at this time.
Have you filed your motion?
I have not filed one yet, Your Honor, but I don't believe the state is opposing.
That's correct, Your Honor. I haven't filed any information because I requested additional details from law enforcement. They're supposed to provide me with a supplemental report, and before I get that, I don't feel comfortable filing any information. And I cannot disagree about the ROR. The only thing I was asking, because of the nature of the charges, the allegation that he failed to register his address and he is transient, that he has a GPS monitor.
Okay, so you're saying ROR to PTS with the monitor,
Yes, Your Honor.
Yes.
and you'd agree to that?
Yes, Your Honor.
All right, so I would need a written order on that because of the confusion that's arisen between the communication with the jail, PTS, and the court. So we'll say that no information is filed. The state's agreeing to the ROR at this time to pretrial services, standard conditions, plus the provision of a GPS to be attached before his release at $1 a day based upon the defendant's status.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Now, there's some of you here today who don't have a lawyer assigned to you yet. Is that right? Raise your hand if that's the situation. Now, I'm going to call you down one at a time, and we'll discuss. As you've already heard me, I've asked the state if there's an offer to dispose of your case, and I'll ask them to do that. If you want a lawyer to represent you, everyone's entitled to a lawyer pursuant to both the Florida Constitution and the U.S. Constitution. If you're unable to afford a lawyer on your own, then the state is required to provide a lawyer to you at the state's expense. That requires you to complete an application for the appointment of a lawyer. It's a goofy government form. If I hadn't been doing this for all these years, I wouldn't know how to fill it out. So I ask people to fill it out here in the courtroom, and I look over it because there's some areas that are common mistakes because it's a goofy form. For instance, at the top, it talks about your income. That's income from employment. Later in the form, it talks about your income from other sources like child support, retirement, Social Security, disability. If you combine both of them in the top line, that's wrong. But the form doesn't tell you that instruction. So I'd like you to fill it out here, and then I go over it to be sure those areas where there's common mistakes are made are corrected before we turn it in to the clerk. So if everybody who doesn't have a lawyer, if you'll just line up here, and then we'll call you one at a time to address that and get you the form, okay? Come on down, sir.
Go ahead, Mike.
What's your name, please?
Michael Allen Lyon.
All right, and you've already completed the form, right?
I think so.
All right. And you say you have 2 dependents?
Yes, sir.
There are 2 people that you're required to support in your household?
No. I'm just me. They take care of me.
I think there's some confusion. I believe he was helped to fill that out.
Yeah.
Okay.
And the person who helped fill it out, they have 2 dependents.
Okay. So, and your income is your retirement and your VA?
Mm-hmm. Yes, sir.
All right. And, all right, and your family helped you with your bond?
Yes, sir.
All right, and other than that, okay, it appears that you do qualify. I'll tender this to the clerk and I'll appoint the public defender. If the clerk says you don't qualify, they'll tell you why. If you think the clerk is wrong, get everything you have that shows the clerk is wrong, give it to your lawyer and bring it to court with you next time, okay?
Okay, sir. Thank you.
Do we have any information for Mr. Lyon?
Yeah, I believe it was filed this morning.
That's correct, it was filed this morning.
We'll acknowledge that the information has been filed. We'll waive formal reading, enter a plea of not guilty, and ask to leave this set for the May 11 court date, Your Honor.
Okay, and is there an offer from the state at this time?
No, Your Honor, I intend on speaking with Mr. Cochran about it.
Okay, all right, we'll leave it on for 5/11. Stay in touch with your lawyer and be back in court on 11 May, please.
Yes, sir, thank you.
Thank you now, good day. Come on down, please. And your name is?
Aspen Ray?
Last name Ray?
Yes, sir.
Okay, and this appears to be 26 CF 239. Do you want to have a lawyer represent you?
I don't know if I,
Huh?
yes, I guess. I don't know.
Okay, and the form will be given to you, fill it out, give it back to the bailiff. Don't leave until you turn the form in and get a new court date, okay?
Okay, thank you.
All right, thank you. All right. Who's next? Yes, your name is? All right. And you're here without a lawyer? Do you want a lawyer to represent you?
Yes, sir.
Are you able to forward one on your own?
No.
All right, have you completed the form?
No, I just got it today.
All right, go ahead and fill that out and turn it into the bailiff. Don't leave until you turn it in and get a new court date, okay?
Yes, sir.
Okay, thank you. Come on down. Yes, your name is?
Tamara Sheffield.
Sheffield? I think Mr. Koch represents you. I
Judge,
think.
Ms. Sheffield in 26 CF 272. Back on March 3rd, there was an order signed relieving the public defender's office, and RCC was appointed. That's what it looks like on the clerk's side.
Ah,
That's the last time I had Ms. Sheffield.
and I guess maybe that crossed with our technology issues, because I don't see Ms. Jaquith here. Is she in the courthouse, or is she downstairs maybe with Judge Clark? Do we know?
If not, I can reach out and do that right now.
Yeah, I see the order, but it's still showing you on the progress docket, Mr. Koch.
If that's the case, I can enter the not guilty today. Request this to be kept on that 5/11 docket, and that should give enough time for everything to clear, Mr. Kett to get on board.
All right. And State, is there an offer on Ms. Sheffield's case?
Sheffield.
With an S.
Say again? Okay, thank you very much, Ben.
Oh, okay. 26 CF 272.
Sorry, I did not know this was my case. Your Honor, I would do adjudication of guilt, 2 years probation, substance abuse evaluation, and treatment recommended, and 24 hours of community service work.
All right.
Your Honor, since we had that conflict, I wrote down, I'll be entering a not guilty. I wrote down the next court date of May 11th at 9 a.m. RCC will be your attorney, Mr. Quett. And I did write the offer on this plea form, so you can bring this when you have a meeting with her. If we could do that, this.
Yes, and if you'd approach with Mr. Gomez real quickly.
Absolutely.
Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
All right. So you'll be notified, Ms. Jaquit's going to be your new lawyer, and we'll set this on 11 May. But in the meantime, get in touch with Ms. Jaquit, and she'll give you instructions on what you need to do and how to proceed.
Okay, thank you.
Okay, thank you now. Good day.
God bless.
All right. Yes, sir? You're here without a lawyer? Come on down. What's your name?
Grant Schwoy.
Last name again?
Schwoy, S-C-H-W-O-Y.
Okay. And you're here today without a lawyer. Do you want a lawyer to represent you?
I was waiting to get one myself, retain one, but I was waiting on a check from my insurance company that I did a job for, and they were just dragging their feet. I should have one this week.
Okay, so if you think if we continue this to 4/16, you'll have enough time to do that?
Yes, sir.
I know it's right after tax day, but that's my date. All right, so we'll just continue the arraignment to 4/16.
Thank you,
Okay?
Your Honor.
And as soon as you're able to retain your lawyer, get them on board, because if you hire them on 4/15, they're not going to be ready for 4/16. Does that make sense?
Yes, Your Honor.
Okay, good deal. Thank you. All right. Good afternoon. Your name is?
William McDaniel.
McDaniel?
Yes, sir.
Is that William Marcus McDaniel?
Yes, sir.
All right.
Junior.
All right. And you're here today without a lawyer. Do you want a lawyer to represent you?
Yes, sir. I'm trying to get private counsel, but just in case, I was trying to fill out the PD form, but gotten a little older, you can't really see the small letters, so.
All right. So you're not able to fill it out?
I can't see it. I don't have my glasses with me.
All right. So take the form with you, fill it out. I'll provisionally appoint, but be back in court on 4/16.
Yes, sir.
So we can review your status.
Yes, sir.
Okay? Is there information filed?
Yes, sir.
Okay.
Your Honor, we acknowledge receipt of a one-count information, enter a plea of not guilty, waive formal reading, and ask to leave this set for the May 11 court date.
All right. Offer from the state.
Adjudication of guilt, 3 years of probation, 48 hours of community service work, $4,027.82 in restitution to Mr. Chadwick Cameron.
Okay. You got that number real quick. 4,000.
$27.82.
82 cents. And restitution. Okay? All right, very good. Stay in touch with your lawyer, be back on 5/11, complete the form, and turn it in, okay?
Yes, sir.
All right. Aspen Ray, please. All right. And you indicated the bond here, but you didn't mark who helped you, who posted the bond for you. Did you do that yourself or your family do that?
No, my family did it for me.
Okay, very good.
But I can tell you it was Bird's Bill's bondsman.
Say again?
Bird Bill's
Okay.
bondsman.
And you have no dependents,
No, not at home, no, sir.
and you've got your VA as your only source of income?
Yes, sir.
Okay, all right. I'll find that you do qualify, and I'll appoint the public defender to represent you at this time. If the clerk reviews this and says you don't qualify, they'll tell you why. If you think they're wrong, then bring everything you have that shows they're wrong with you to court next time and give it to your lawyer as well, okay?
Thank you.
Your Honor, now being appointed, receiving the information, waive formal reading, enter not guilty. I was speaking with Mr. Snell about potential offers earlier. We want to review the driving record and potentially maybe resolve this with a misdemeanor no valid. So at this time, we'll just say there's no offer currently.
Okay.
You're welcome. That's our next court date. Okay. Molly Eski is right there. She's going to be your attorney.
Thank you.
All right. Stay in touch with your lawyer and be back in court on May 11th, okay? Thank you now.
And you can call and make an appointment before that court date.
Okay.
Which I recommend.
Okay.
Are you free to go?
Thank you.
You're welcome.
All right.
Judge, may I call a client that just came in the courtroom?
Yes.
Miss Tanya, last name Pratt, 26 CF 270.
Yes.
She's present and approaching. Thank you, Your Honor.
You're welcome.
We will enter not guilty, waive formal reading. There's a current 6-month offer in the county jail. Thank you. And we're requesting if we can keep this on the 5/11 docket.
All right, so ordered. Stay in touch with your lawyer. Be back on May 11th, okay?
Yes, sir.
Thank you now. Good day.
Take this. That's our next court date. Make an appointment. Miss Yeski is sitting right there. She will be your attorney. But you're free to go. You're welcome.
All right. All right, come on down, Mr. Mendonia. All right, so your sole source of income is the Social Security that you listed, and you've indicated the motor vehicle. And the motor vehicle, is that what you believe the net value is?
Yes, sir.
Okay, so do you have a loan on it?
No.
It's okay, it's free and clear, all right. It appears you qualify. I'll appoint the public defender to represent you. The clerk will review this. If the clerk says you don't qualify, they'll tell you why. If you think the clerk is wrong, get everything you shows the clerk is wrong, and be back and give it to your lawyer and bring it to court with you next time, okay? Yes.
Your Honor, we acknowledge receipt of a one-count information, waive formal reading, enter a plea of not guilty, and ask to leave this set for May 11th.
Is there any offer?
Yes, Your Honor, it is a withhold of adjudication, 18 months of probation, substance abuse evaluation, and treatment recommended, 24 hours of community service.
All right. Stay in touch with your lawyer and be back on May 11th. All right, thank you. All right, good day. Now, Mr. Durrell, you've got your motion notice for today, and it's a motion to withdraw, correct?
Yes, Your Honor.
All right. Jonathan Wright, Mr. Wright?
Yes, sir.
Yes, sir. Come on down. All right, and you've seen Mr. Durrell's motion, and you noticed here for today.
Yes, sir, if it's the most recent one, he sent a couple of them.
Yep.
But the most recent, yes, sir, I've seen.
Okay, all right.
Yes, Your Honor. It's gone back and forth with Mr. Wright about whether or not he is going to agree. At this point, I guess I'd ask Mr. Wright, do you have any objection to my withdrawal?
I do not, Your Honor.
Okay. All right, and I'll enter the order.
Thank you very much, Your Honor.
All right, thank you now.
Thank you.
Are you going to want new counsel?
I just drove in from New Orleans, so I live over there half the time, and I have a meeting with new counsel.
Okay, very
This
good.
afternoon.
And so this is currently set on 5/11, right, Madam Clerk? No, we didn't reset this.
No, that's right, Your Honor. We just passed it to today.
All right, we'll set it on 5/11. Get your lawyer on board as soon as possible so the case can move forward, okay?
Yes, sir.
All right. Mr. Dees, you got a change of plea, is that right?
Yes, sir, I do.
All right, let's take your change of plea.
Thank you, Judge. Robert Dees on behalf of Gary Richard Spencer, 25 CF 408. Your Honor, at this time, he's going to withdraw his previous entered plea of not guilty, tender one of no contest to the court. Do have an executed plea and sentencing agreement together with a score sheet. May I approach?
Granted.
Judge, I forget if you want me to call the attorney.
Yes, please.
The agreement with Mr. Spencer, Mr. Snell, is that he'll plea as charged. Adjudication will be withheld. He'll be placed on probation for a period of 24 months. That cost will be $40 a month, cost of supervision.
God bless you.
Due to the ever-moving target of fines and costs, I did put in the plea agreement, fines and costs mandated by statute, so I'd rely on Madam Clerk to give us the accurate amount, if it would please. No contact with the victim, Toriano Cowart. Defendant must consult with his primary care physician to determine his fitness to operate a motor vehicle, provide that proof of the results of the consultation to probation within the first 60 days of probation. He's not allowed to drive an automobile at night pursuant to the terms of this probation. Restitution to Toriano Cowart, we'd ask the court to reserve as to the amount, but to order restitution. Mr. Spencer may terminate this probation after 12 months if all requirements are met and there have been no violations.
All right. That's the state's agreement.
That is, Your Honor.
All right. Raise your right hand, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You can put your hand down. You heard what Mr. Dees said, and you signed the written plea form.
Yes, sir.
How old are you?
80.
How much education do you have?
Sure.
How much education do you have? How much school?
3 years of college. Sir.
Okay. You able to read and understand the plea form?
Oh, yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in the form what Dees just told me?
Yes, sir.
All right. Do you understand by this plea you're pleading no contest to the charges?
Yes, sir.
And that tells me you believe the state could prove your guilt and you're not going to get tested.
Yes, sir.
All right. And by doing this, you understand you're waiving your right to a jury trial where the state would have to prove your guilt.
Yes, sir.
And you've heard Mr. Dees announce the terms. Adjudication will be withheld. You're going to be on 24 months of probation. There are some special conditions regarding your driving, and you've got to comply with those.
Yes, sir.
And if you have, and restitution may be established in the future. And you can complete your probation at 12 months if you've got all your terms completed and you have no violations.
Yes, sir.
Mr. Dees answered all your questions about the plea and how it affects you.
Yes, sir.
You're satisfied with how he's represented you.
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Judge.
Thank you, sir.
And if you'll check in with probation before you leave, okay?
Judge, good seeing you. Thank you for entertaining this plea this afternoon.
You're welcome. And counsel, if you'd approach real quickly. All right. We'll be in a recess.
All rise.
I can have one moment.
Yes. Is there an offer?
An adjudication of guilt, 7 years in Department of Corrections, that's a mandatory minimum, and a $50,000 fine is also mandatory.
All right, thank you very much.
Come on. Next we have Alicia Lewis. Lewis?
Yeah, we have Mr., how do you say your first name? Laquelia? Yeah. Okay. We have Mr. Laquelia Lewis, case number 26 CF 0222. Will acknowledge receipt of a 1-count information, winner a plea of not guilty, waive formal reading. I asked him to set this for, let's file a bond motion. The state doesn't oppose us filing it for next week.
All right, set it on 5/11 and a bond motion on 3/19.
Yes, Your Honor, and I'll get the bond motion filed.
What was that? What did it get you?
9 o'clock, or are we expecting witnesses?
Yeah, I'll come talk to you.
9 o'clock is good.
All right, that was going already.
9 a.m.
Get you out. I'll come talk to you.
Offer?
So if I heard okay, then there you
We
go.
were awaiting restitution.
Something you ever know? No, see, that's what I'm talking about. No, that ain't going for that one.
Okay, we're not.
I mean, what they do the probation thing or whatever you gotta do. I don't care what it is.
All right, if you get your motion filed timely, we'll set it on 3/19.
Thank you, Your Honor. And I believe that concludes my business.
Madam Clerk, any other cases assigned to Mr. Cochran we need to address?
Nope, that's all we have.
Okay.
Thank you, Your Honor.
Thank you, Mr. Cochran.
Ronald Roberts.
And I show one case without counsel. You wish to be appointed on that case?
Thank you, Judge.
He's appointed.
Judge, this is Mr. Ronald Roberts. I want to list a case. We have the new law violation in 26 CF 210. Then I have the PD appointed to 2 VOPs. Those case numbers are 25 CF 822 and 25 CF 1606. For the new law violation, the new law case, Judge, information has been filed. We'll be entering a not guilty, waive formal reading. That currently has a 7-year min-man due to the nature of the charges. I'm requesting all cases to be kept together and to be set for that 5/11 pretrial date at 9 a.m., Judge.
All right, 5/11 it is. Thank you.
Thank you, Judge.
This way, sir. John West.
Mr. John West before the court, Jason McKinney on his behalf. We would acknowledge receipt of a 3-count information, waive its formal reading, enter a plea of not guilty, ask for this to remain on the scheduled pretrial court date, which is May 11th, 2026.
All right. Any offer from the state?
5 years Department of Corrections.
All right. On 511.
Yes, sir. Mr. Pelletier? Jeremy Pelletier?
Jeremy Pelletier, 26 CF 223, Your Honor. Judge, will enter a not guilty, waive formal reading. Currently, I have a score sheet sent over showing a 21-month current DOC sentence, but I haven't had an offer currently conveyed for me.
Yes, I don't have it yet. We can discuss, and maybe we can reach an agreement.
Absolutely. So at this time, Your Honor, we request to be kept on the 511 pretrial docket.
511 it is. Thank you.
We'll be out to discuss privately at the jail.
Sean Perkins?
Sorry. Judges, Mr. Sean Perkins, if I may have a brief moment just to discuss
Yes.
an offer. Now, this is Mr. Perkins, and we're here on the 26 CF 271 case. Mr. Perkins also has a case set for 319, if we can address it this afternoon, and that's going to be 2026 CF 344.
344.
Yes, Your Honor.
You have that, Madam Clerk?
Yes, Your Honor.
Excellent, Judge. Thank you. This afternoon, we do have a global offer. I'm going to announce the terms. It is in the 2026 CF 271, count 1, and 2026 CF 344, count 1. This will be adjudication of guilt, 4 years of standard probation, $40 per month cost supervision. There's $515 in court costs, case number 26 CF 271. There's $515 in court costs in case number 26 CF 344. $200 in defense costs, $50 PD application fee. We have 48 hours of community service, $794.13 in restitution to the city of Mary Esther, $275 in restitution to Advanced Sacred Hope Academy. There's no return to Advanced Sacred Hope Academy, located at 124 East Miracle Strip Parkway, number 503 in Mary Esther, Florida, 32569. Now, there's an auto-terminate probation at 2 years if all conditions and costs are paid and there are no violations. Now, in 26 CF 344 count 2, there's an adjudication of guilt and credit for time served. Now, on the plea form, Your Honor, it is printed out, but I did have to handwrite the counts and how it's structured. I initialed by it, and my client also initialed by it. If I may approach with a signed plea form and a score sheet.
Granted. Raise your right hand, please. You swear or affirm to testify truthfully in this matter under penalties of perjury.
Yes, sir, I swear.
All right, you put your hand down. You heard what Mr. Koch said and signed the written plea form.
Yes, Your Honor.
All right. How old are you?
37 years old.
How much school do you have?
High school with a little bit of college, community
All right.
college.
You able to read and understand the plea form?
Yes, Your Honor.
Did you do that before you signed it?
Yes, Your Honor.
And is what you read in the plea form what Mr. Koch just announced to me?
Yes, Your Honor.
Do you understand that you're pleading no contest to the announced charges?
I comprehend.
And that means to me that you believe the state could prove your guilt and you're not going to contest that.
Correct.
And by doing this, you understand you're waiving your right to a trial by jury where the state would have to prove your guilt.
As written, I understand.
All right. And in this case, you'll be adjudicated guilty, be on 4 years of probation with the stated terms and conditions and the restitution that was discussed, and you can't go back to the places announced. And has Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
And you satisfy what he's done for you?
Yes, sir.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you.
Best of luck.
Devin Filia in 26 CF 249, Your Honor.
All right.
Judge, will be entered not guilty, waive formal reading, request this be kept on the 511. In this case, Mr. Gomez still has to speak with the alleged victim to give out a formal offer, Your Honor.
All right. All right, we'll set it on 511.
Thank you. You take that and follow that. They'll be out to the county jail. You should follow that, Deputy. Certainly.
Next we have William Reed.
Judges, Mr. William Reed. I have two case numbers, 26 CF 227, 26 CF 244. Judge, will be entering not guilty for both cases.
I'd like to clear that and take care of everything today, if that's possible.
Okay, I'll address that right now. Currently, there's not an offer, Your Honor, to be conveyed. Speaking with Mr. Snell, they're looking for potentially the 90-day program and the mental health board. So unfortunately, we cannot resolve both these cases today. I'll be entered not guilty on both of them. Request this be kept on 511. But if we do get an offer, I can certainly bring you in sooner.
You mean 90 days?
Next, we have Skylar Robertson. Temple.
Judge, I first want to notate, I think we did it last time too, his first name is Jacob. I just want to make sure it's accurate, but this is Mr. Roberson. And I like to give all 4 cases I have with him. The 26 CF 279, which is on the docket, but I also have Mr. Roberson in 25 CF 503, 25 CF 1435, and 25 CF 1638, Your Honor.
All right, go ahead.
Judge, at this time, I'd like to set my client for Monday. Speaking with Mr. Snell, we are working on a global offer to resolve all of these cases. These are all violation of probation, and we'll enter the not guilty, waive formal reading on that 26 CF 279 case.
Yeah, so just set it for change of plea on 3/16?
On Monday, yes, Your Honor.
And you've got the 3 VOP cases to travel with, Madam Clerk?
Yes, Your Honor.
Okay. And if it doesn't resolve, then we'll take care of case status then?
Yes, Judge.
All right, very good, thank you.
Excellent. I'll see you back Monday. All right, Jacob.
Next, we have Scott Lutter.
Judge, Mr. Scott Rudder in 26 CF 294, if I just may have a brief moment. Judge, Mr. Snell reached out and provided me a 3-year probation offer. If I can pass up Mr. Rudder so I can get an appropriate plea form filled out.
Yes, sir.
Thank you.
Hold Mr. Rudder for completion of plea.
Yes, sir. Right, hold on, number 31, Rudder. He's gonna come back real quick. Yes, we have Matthew Strong.
Hey, Matthew. Judge, this is Mr. Matthew Strunk on 26 CF 324. I'm also going to provide a case number. We are not appointed yet. It's a VOP without a court date, so I'd like to provide that. It's 23 CF 2795. That was 23 CF 2795, and that will be a VOP that was, I believe it shows as open.
All right, you're appointed on the 279 case.
Thank you, Your Honor. In the 26 CF 324, we will enter a not guilty, waive formal reading, and request both cases be kept together and set for the 5/11 court date.
So ordered.
All right.
Susan Stallings.
Judge, Ms. Susan Stallbitz is here in 26 CF 284. Good afternoon, Susan. Judge, we'll be entering a not guilty, waive formal reading. The nature of these charges is a 7-year min-man. That's the current offer, though we're not, that's why we're entering a not guilty. Okay. So we request this be kept on the 5/11 pretrial docket, Your Honor.
So ordered.
This by Ms. Dalton.
It will be, yes. Yep.
Next, we have Swatsell.
Judge, Ms. Watsell in 26 CF 278. Judge, we will be entering not guilty this afternoon, waive formal reading. Request this be kept on the 5/11 docket. Due to the nature of these charges, it's a 7-year minimum mandatory.
All right. So ordered.
Hold on to this. Thank you. You're welcome. And Your Honor, that.
Ernest Powell.
Sorry. Okay. Ms. Jessica, do you have that case number for that case?
Sure.
Brother?
Yeah, I am.
Thank you. And Mr. Snell can help you. Oops, sorry. And this is on our 2 o'clock, Your Honor, just switching gears. This is Mr. Ernest Powell, and this is we have 3 case numbers, Your Honor. 24 CF 2864, 25 CF 1136, 25 CF 1985, Your Honor.
Yes, sir.
Judge. And this was back in November 17th, 2025. We submitted a signed plea form stating that we are going to plead to the bench with a cap of 65.325 months. If we can proceed with some testimony from my client, Your Honor.
Granted.
If we
Raise your right hand.
Yes, sir.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right.
Thank you. Mr. Powell, can you just please state your full name for the record?
Ernest Lee Powell Jr., sir.
Okay. Leave that for you. I'd first like to ask you to share some circumstances about your 3 cases you have open. I know you've prepared, so please, I kind of want to open the floor to you to just explain to the court what you wanted to share.
All righty. Well, Your Honor, in my case, 2024 CF 2684, and following with 2025 CF 1136, these 2 cases stem from one incident. And I just wanted to state with you, Your Honor, with certain circumstances and certain laws that I was able to, do a little research on and give me some little leverage in my situation. Well, on the day that the initial traffic stop on the vehicle, and I was charged with fleeing and looting, it said I was driving under the speed limit while failing to maintain lanes. It says the officer activated his lights, the vehicle failed to yell, continued to travel between 30 to 40 miles per hour in a 55 mile per hour zone, continued to fail to stop for approximately 9 minutes. So later on into the traffic stop, him being in pursuit of me or whatever, the officer stated that, he stated multiple times that the vehicle was a failure to stop. It was a failure to stop. It continued to fail to stop. He kept saying it over and over in the affidavit that it was a fail to stop. Well, in the fleeing and looting statute 316-1935, that's a fleeing and eluding statute. Well, it said that I failed to stop, and I actually ended up, after 9 minutes of stopping, honestly, Your Honor, to tell you the truth and everything that you asked me to be honest about. I was going through a lot of things at the time. I was battling with my mental disorders, transitioning back into society, just, trying to do what I was needing to do. And at the moment, at the time, honestly, the reasons that I didn't stop at the time, I was unaware of the reason for the officer from another county had jurisdiction to pull me over. I'm thinking that this was an officer from another county. And on 293, Your Honor, that's a dark road, and it's like on a main stretch. So I did come through. I did fail to stop, but I ended up stopping on my own accord. I never did intend to flee. Well, in
That's the fleeing and eluding statute, the 316-1935. And the statute 316192 is a reckless driving. And the statute for that is any person who drives a vehicle willful or wanton disregard for the safety of persons, of property, or property is guilty of reckless driving. In a fleeing and eluding statute, a reckless driving is not a fleeing and eluding, but a fleeing and eluding is a reckless driving. So with the ways that this case was written up and how I ended up stopping and being apprehended, and they said I actually did stop, and I never attended to elude, which I did flee for an approximate amount of time, or I failed to stop. I didn't actually flee. It said that I failed to stop for an approximate amount of time. The statute that I should possibly be sentenced or charged with would be considered a reckless driving. And the conviction for that, a first conviction for that is a 90-day or a fine, a 90-day sentence or a fine from $25 or no more than $500. Okay, in the case number 2024, the officer that initially got behind the vehicle, she said that it was a sole occupant of the vehicle, and she never identified nor gave a description of the driver or his clothes until she was informed hours later of the description that the officer had given her. She never identified or made contact with the driver of the vehicle, and she said it was only one occupant in the vehicle, but it was two individuals in the vehicle, Your Honor, and she stated in her report that it was only one, and she never identified, and she only gave her description later on after the timestamp would prove that she gave her a description of the driver after they informed her of what the driver was wearing. On those two cases, I just wanted to share those to give you a little information, you know, when making your decision. And in my case, 2025 CF 1985, I was charged with
I'm sorry, I was
Okay.
just gonna help you out. The 1985 case, there's 5 counts.
Okay.
Just to help you out.
All right, the initial encounter started from a smell of marijuana. The officer was coming from one direction, I was traveling in another direction. He said he smelled marijuana. He followed me a few blocks. I pulled into an apartment complex. He states in his report, I immediately exited the vehicle. He never initiated a traffic stop. He never initiated a traffic stop. And he said that the reason his probable cause for pulling me over was for a smell of marijuana. Well, with the Florida statute 581-217, the law had been changed. I wasn't aware of it, and I did a little research, and I seen that. Hold on, give me a minute, y'all. I'm all over the place right now. It states that the controlling law states that the legislator has determined the smell of cannabis standing alone no longer can make it clearly or immediately apparent that the substance is illegal or contraband. The incremental legalization of certain types of cannabis at both the federal and state level has reached the point that its plain smell does not immediately indicate the presence of an illegal substance. And thus, the odor of marijuana alone does not support probable cause to justify a search. Thus, plain smell no longer establishes probable cause. And it states that in Baxter v. State, Head Note 12, as a result, the smell of cannabis cannot on its own support a detention. Officers are required to have a reasonable belief that an item is contraband and an illegal substance prior to its seizure under the plain view doctrine. There must be something about the circumstances when considered in total that reasonable raises a suspicion that a crime has been or is being committed. The smell of marijuana alone cannot create probable cause under the state and federal constitution, where changes to the law eliminated the main pillar of supporting the plain smell doctrine as applied to possess or use of marijuana. And when I say in that case that there wasn't no vehicle stop, no traffic infraction or anything, the sole incident stemmed from the smell of marijuana. And it says that when a search or seizure is conducted without a warrant, which I didn't give them probable cause from the vehicle, and I exited the vehicle, so I didn't give them probable cause. I didn't give them consent to search. And what the smell alone, that's not reason for a probable cause. And it said the government bears the burden of demonstrating that the search or seizure was reasonable. The state has the burden to prove an exception to the warrant requirement. Until the state demonstrates that illegal cannabis has an odor that is distinct from legal cannabis, the justification for the exception, cannabis odor, is very distinctive. It no longer exists. And it says that, in a matter concerning cannabis, the smell of marijuana does not develop reasonable suspicion of criminal activity, as required by U.S. Constitutional Amendment 4, because the record was devoid of any circumstances that would have led a reasonable officer to believe that the defendant was unlawfully possessing cannabis at the inception of the investigation detention. It follows, and it falls under the evidence and that was seized from the search falls under the fruit of the poisonous tree. And the doctrine is a court-made, and the fruit of the poisonous tree doctrine is a court-made exclusionary rule which forbids the use of evidence in court if it is the product or fruit of a search or seizure or interrogation carried out in violation of constitutional rights. In all, the exclusionary rule encompasses both the primary evidence obtained as direct result of an illegal search and seizure and evidence later discovered and found to be derivative of an illegality. I just wanted to share those things with you, Your Honor, a few mega factors in my case that could possibly help you in, determining your sentencing in my case. And I just wanted to share those points with you concerning my case. And I further wanted to speak. I don't know if you had to do what you needed to do or if you want me to continue to.
Like we talked about, I would like to move to number 2 we talked about.
Okay, go ahead.
At this time. Thank you, Mr. Powell. I'd like to move to the evaluation that Dr. McDonald conducted with you. And he shared that there's some diagnosis of post-traumatic stress disorder and adjustment disorder. So for this question, I want you to focus on your life experiences, and I want you to address this court of your post-traumatic stress disorder and the adjustment disorder. Please, Mr. Powell.
Right. This is the part, Your Honor, where I wanted to give you and wanted the court to have my undivided attention. This is where I really wanted to, get personal. I ain't coming in here today to make no excuse, Your Honor. I take remorse for all my actions prior and current. I'm not standing before you saying I'm an innocent man, or I'm not saying that I'm guilty, but I'm before you, Your Honor, and I take accountability for my actions. And I don't, like I said, I don't want to make no excuse. There's plenty of men that come before you each and every day. But as for me and my actions, Your Honor, I take full accountability. But I've been a trying young man. I ain't no stranger to this courtroom. You know me. You sentenced me a couple times, and I've accepted every sentence you ever gave me respectfully. Walked out of here and took it with no ill will, no hate towards you in my heart or nothing. But when I was a child, Your Honor, and this is Bible scripture, but it's just something I want to share. When I was a child, I thought like a child, I spoke like a child, I understood as a child. And I'm standing here and telling you today, when I became a man, I put away my childish ways. And today, I'm standing before you, and this is my transition from a boy to a man, Your Honor. I have had a troubled childhood. I have had a troubled upbringing, and I've been in situations that caused me to, end up doing some incarceration. Every time, you get this label upon you, this is what people look at you as. This is how people feel about you. So, when you're getting out of prison, people already count you out. They don't think that you can amount to what you may actually present to them. People say a lot of things while they locked up, and people say a lot of things when they come home, but, it's a very small percentage that actually execute with whatever it is that they spoke upon prior to their release. But as for me, Your Honor, man, I'm at a point in my life where going in and out of prison, I never had the opportunity to come home and adjust to society with the proper support or the opportunities to be in the situation to get my life together in the best situation or the best possible environment that I needed for myself, because I always would possibly end up back in the same environment or dealing with the same people. Well, for one, that's one thing that I stand more on than anything. It's changing my people, places, and things that I involve myself with, that I attend, and people that I socialize and associate myself with, Your Honor. But you know, for me, it's like giving so many years of my life to the system and coming home and really trying to be the best version of me and get it together. And you know, you giving your all and you trying to do the best that you can, and it don't seem like it's enough. And nobody can't see that in you. And everybody just looking at it as for what you've done. Don't nobody look at you for who you can become, because you're already labeled. So when you trying your hardest to give everything that you possibly can to become a better person, you know, to make a difference, to make a change, and people can only see you for what you've done, it's hard to adjust, Your Honor, back out into a society. And you know, you see a lot of people come in here. A lot of these people, they come from prison or whatever background that they come from, county jail, and get out and they come back. Living on the other side of that law, Your Honor, like I say, I ain't come to make no excuse. It's different. It's hard. And I ain't just speaking for me today. You know, I'm concerned. I worry about a lot of people, Your Honor, and that may be a problem for me, my heart. But, you know, it's hard for us on this other side of this law. You know, y'all got a job to do, and, you know, I respect that. Y'all come here, y'all got to do what y'all got to do to keep the community, to keep the county safe, and keep the people safe. But for a lot of us, for some of us, we really try. We really want to do the right thing. But it's like when we got a label on us, you know, and can make an honest mistake or make a bad decision, they're not going to look at you as a man that's trying to do the right thing and made a bad decision or an honest mistake. They're going to look at you for what you've done. And I'm standing here before you on that, and this is my testimony, and I'm telling you, speaking from experience. I done been to prison numerous amounts of time. I'm 36 years old. My oldest son, he 18. He graduated this year, Your Honor. And I done missed out his whole life. I got a 16-year-old, I got a 10-year-old, and I got a 7-year-old. And from missing out from my oldest son, he finna graduate, and my other 3 children next up going through the same thing that I just took my oldest son to. You know, that's something that hits me and touches my heart, touches me in a different way. So it's like I say, man, going in and trying to transition and adjust back out there into society, and you know you already got the deck stacked against you. So you liable to make a mistake, or you liable to make an error, or you liable to do something that cause you another incarceration or another lockup or something. So you know people gonna hold you accountable for that, and they're gonna look at that as you're not able, you're not capable to become a better version. You're not able, you're not capable to be anything different. So they're gonna look at you and they're gonna judge you based off of what you've done. And me, Your Honor, I live on a certain model that I hold myself accountable by that. You know, if you treat a person as they is, they remain the same. But if you treat a man as we could be, he'll possibly become the man that he should be, Your Honor. You know, and I'm standing before you today. I know I'm speaking a lot around what I'm speaking on, but I want you to hear my heart, Your Honor. It's like, I'm tired of suffering. I'm tired of struggling, giving my all. You know, I'm always there for everybody else. I got court today, and ain't nobody out here for me. I come home every time, and I don't never give myself the chance, the opportunity, because I'm a loving individual. I come home, and I give everybody else more of me than I give myself. And at this point in my life, I won't give myself a chance. And I'm asking, and I'm hoping that the court can give me an opportunity and show me mercy and give me the opportunity to give myself that chance and prove not only to the courts, but to my county, Your Honor. I wrote you a letter. I got a few goals, a few plans. You know, I want to use my past experiences from my mistakes and the lessons that I learned and give back to the community and, you know, be a mentor or open my program. I have a program that I call Boys to Men. You know, I want to reach out to the youth and show them that y'all don't have to go this way, you know, and be the guidance to them that I didn't have. So I want to take the mistakes that I've made in my life and use it to help the younger generation, the next generation, be able to be a part of my community and show the courts and show the community that I'm able to do the right thing, that I'm able to make a difference. and that I'm worthy, Your Honor, that I can make a change, that I can make a difference, that I can do better. I want to do better, and I know I can do better. And the things that I've done is my past, and that's no longer who I am. I know I'm standing before you today, and I may have made mistakes, Your Honor, but, you know, like I say, it's hard to transition back out of here when you don't got the support, your family not there. You know, they count you out. They think you just going to continue to be the person that you once was, and they ain't trying to take the time out to know what you're dealing with, what you're going through. You battling with mental disorders. You battling with everybody trying to lie on you, steal from you, manipulate you, gang stalk you, monitor your moves. You know, you're just trying to do the right thing, but everybody's trying to take away from the goodness that you're trying to give. They don't see that. They can't see the goodness in you. They can't see that you really trying to better yourself. And they're not trying to be the support that you need to help you better yourself. And that alone, it makes it hard to adjust back out into society and, you know, really have that opportunity to get ahead, the opportunity to get yourself stable and, you know, get you a foundation and get your feet up under you. But, you know, Bridgeway is I'm not trying to coerce you or tell you anything but about sentencing me, but I just know with certain things that and programs that Bridgeway offer, it'll be a benefit of me and allowing me to adjust back into society with programs that they got to offer. You know, they help with assistance and housing and a lot of things that they help with. And it possibly can help me get in a position to execute my goals and my plans and do the things that I want to do. I no longer want to be labeled, be the person that I'm labeled as. I want people to see me for who I am, who the man God made me to be. I'm worthy, Your Honor. I deserve a chance, and I owe myself that chance. And I just want to ask the court if they able, if you could find in your heart to show me mercy and give me that chance and that opportunity to give myself a chance and put myself first. Like I say, man, it's been so many times and so many years where I come home and, you know, I'm always trying to be available to everybody else. I'm always trying to do right for everybody else. But I ain't never doing this for myself. And here it is when I done spread it myself then, and I done gave everybody the goodness of me that I got to give, and I made one bad mistake, and I'm standing before you. Ain't nobody there to support me. Ain't nobody there to look at all the good that I tried to do unto them or all the good things that I done. But if I was to take my time and was to reach out to people, you know, I could have this courtroom packed with all the good things and the good person that I am and, you know, being considerate and kind and, you know, the impact that I done made on a lot of people's lives and the influence that I have over my community, over the youth, Your Honor. But it's just like not knowing how to deal with my mental disorders. But as I'm getting older and realizing that I've had problems and had issues that I was dealing with mentally, and now I know I'm not afraid to acknowledge these things and address these things and, you know, to get the help that I need and to work through these things and learn it's okay to be depressed. It's okay to, you know, go through things in life. We go through things, but it's just about recovering and getting the help that you need to better yourself. And that's where I'm at in life. I want to do whatever that I'm able to do to prove to the courts, to prove to my community, and to prove to myself that I can do the right thing and that I want to do the right thing. And, you know, like I say, that transitioning from prison without that help and just the adjusting part, that's been the sole issue with me getting back out here. It's not that I'm running around being a problem as I once was, violent or, you know, doing anything to harm anybody. The only harm that I possibly was bringing upon anybody is myself, you know, for my reckless decisions that I was making. And, you know, like I say, but when you trying to give people, when you trying to do the right thing and nobody can see the good in you, and you know they count you out, and you know they just looking at you and casting you as a failure. I'm tired of being a failure. I'm tired of messing up. I'm tired of going through these things, Your Honor. I'm just asking for a chance, an opportunity to prove myself and prove to the system that I can make a difference and I can do the right thing and I can do better because I deserve that and I owe myself that, Your Honor. I just wanted to shut up.
And Mr. Powell, just to follow up that, I want to talk about that treatment. So as we talked about, to get a downward departure, part of that is treatment. Are you willing to go to treatment? I just want to be clear on the record here.
For sure.
I'm sorry?
Yes, sir.
I just want to be very clear. Now, we have a couple options. I know Bridgeway, in the past, you utilized Bridgeway.
Yes, sir.
So you're amenable to go to Bridgeway and seek counseling,
Yes, sir.
seek sponsors,
Yes, sir.
individual or group interventions.
Yes, sir.
And
Do community service, and whatever that options that come with attending Bridgeway and their services, I agree to it.
Okay.
Anything that aligns me with getting my life in order and, transitioning and adapting back into society to execute my goals, my plans, and, get my life together, I agree to it.
Now, also, I want to put as many options in front of this court as possible. We tried to go to Phoenix House. They have some programs available. Due to the nature of your priors, you weren't allowed to go to Phoenix House. But in communication with Phoenix, they offered, so there's a Bridgeway, and there's also Crossroads in Chrome. We haven't formally been accepted yet, but if the court deems, we can downward depart and seek treatment there, are you amenable to go to inpatient treatment?
Anything that'll give me the opportunity to transition and adjust back into society and better and put me in the best position to get my life together.
You're willing to go?
Yes, sir.
Okay, I'm just being clear for the record. Those were the main things that we talked privately I wanted you to express, but that was the last question I had. Is there anything else you want this court to know before we move to entering some different evidence? This will be lastly your testimony, but is there anything else that you want this court to know?
Yes, sir. I pretty much said everything, but, my past, Your Honor, you pretty sure it's probably going to be brought up some way or one another, but, y'all made those mistakes. I made those decisions, and, I've grown and I've learned. And these last few months that I've sat in the county, I had time to sit back and reflect on my past and on my future. Just wasting time in my life and, looking back on the things that I've done, that's no longer the man that I am or the man that I strive to become. I stand on my faith, very devout in what I believe. I trust in what I trust in, I believe, and I'm a true man of that, Your Honor, and I'm no longer the individual that I once was or attached to these labels and these titles that I once served my time for and been convicted of, Your Honor. It's possible for us to change. It is possible that people make mistakes and, they learn to get it together. Unfortunately, it's been a little rough start for me. It's been a rough journey for me, but at this point in my life, I'm assured, and I can assure you that I'm ready to do what it is that I need to do to become that man that I know that I need to be and the man that I was made to be.
Excellent. All right. No further questions from my client, Your Honor. Thank you.
All right. State wish to inquire.
I have no questions.
All right.
Lastly, Your Honor, would be to, with no objection from the state, to enter the evaluation from Dr. McDonald to the record. And then I'd have just argument, Your Honor.
We'll admit that it's defendants A, and because of the nature of it, it'd be non-public.
Thank you, Judge. And I'll move to argument, Your Honor.
Yes, sir.
Thank
Do
you.
I have a score sheet, please? Any score sheet objections?
No objection from defense, Your Honor.
What's the total points?
The lowest permissible sentence is 65.325 months, Your Honor.
And no objection, Your Honor.
Go ahead, Mr. Koch.
Thank you, Judge. Defense would like to, the reason for the downward departure, Your Honor, is going to be the defendant requires specialized treatment for a mental disorder that's unrelated to substance abuse or addiction or for physical disability, and the defendant is amenable to treatment. Dr. McDonald's summary and findings, he does state that Mr. Powell has he reported prior diagnosis of post-traumatic stress disorder, but Dr. McDonald did touch on that the records offered of diagnosis of adjustment disorder, which certainly seemed appropriate. So for post-traumatic stress disorder, Your Honor, and adjustment disorder is the conditions I want to focus on. And now moving to treatment, I used a testimony from my client. Anything to get his life back on track, but Bridgeway, the counseling, the sponsors, the individual group, and interventions with Dr. McDonald touched on in his findings. Phoenix House unfortunately did not accept my client because of the prior child abuse. One second. So if this court agrees to a downward departure, I would ask if Bridgeway with probation and those conditions aren't enough, that he be held in custody until I can get him accepted into the Crossroads or Chrome program. Now, it's not only suffice to have a disorder and be amenable to treatment. Of course, this court also needs to review the totality and see that it is appropriate. So that's another prong that needs to be established. So I'm not going to invade that province of Your Honor, but I moved to this court for the treatment for PTSD, the adjustment disorder, that we can deviate below that 65-month cap that we pled to, Your Honor. Respectfully.
Yes, Judge, just to, I think, recap, we have the guideline sentence as 65.325 months in the Department of Corrections. I think it should be noted that in 25 CF 1985, count 1 is a trafficking amphetamine, which is a mandatory minimum of 3 years. So I believe that if this court were to be inclined to downward depart from the guidelines, there would still be a minimum of that 3 years from the mandatory minimum. So I just wanted to kind of address that at the outset. I'm not going to get into the facts of what Mr. Powell was stating with each one of these cases, but I will say that all of that seemed to the state as though a lack of accountability for the actions that he took on those days. And I think, importantly, I want to look at the evaluation that was done by Dr. McDonald. There was a few things that stuck out to me. Namely, and it's towards the bottom of the summary and findings, and I want to point out that in terms of the bipolar disorder, the depression, that appears to be at least self-reported to Dr. McDonald. There's nothing in there that states that she actually viewed any sort of other diagnosis. I think there was one potential diagnosis, I think, of the adjustment disorder, but other than that, there was no official diagnosis that she spoke on. It was more a self-reported diagnosis of those disorders. I want to point out in that the last part of the summary and findings, it stated that, I'm sorry, I have to find this again. He insisted, he being the defendant, I don't need a program, that he learned a lot from the one that he completed in 2022, and that he also expressed belief that attending a residential program now would just be avoiding things, and that he feels he has no time to waste and prefers to go straight back to the community as a whole. He identified that his plan once released from jail would be securing work with a friend, living with his sister, and resuming counseling at Bridgeway. I do want to note for the court that according to the defendant's accounts of the current events, also in that same report, he was living with his sister when these new cases in 2024 and then 2025 arose. And so the state finds that extremely concerning. We don't think that is demonstrating an amenability to the treatment. It seems as though the defendant is trying to outline the treatment that he wants for himself and not willing to accept the treatment that may actually be necessary in this circumstance. I also want to speak on the defendant's criminal history. I believe there is somewhere in the neighborhood of 15 felonies that stem all the way back from 2008, and then there is a somewhat consistent, every few years, getting more and more charges. And it should be noted, I think, that he was attending, or he was in a program in 2022 and then gets incarcerated after that program that he is claiming that he learned so much about. He is incarcerated in the Department of Corrections until September 23 of 2024, and then we see these new charges that started on December 16th of 2024. And so the state feels as though if he was truly amenable, which I think that's the part of any sort of downward departure that I think the state could see possible here would be there was some sort of specialized or disorder that requires specialized treatment. There's several parts to that. One, that he has a disorder that requires specialized treatment, that he's going to go get that specialized treatment, and that he's amenable to that specialized treatment. And when we're looking at Dr. McDonald's report, I wouldn't say that outpatient bridgeway treatment would be satisfying that specialized treatment that's needed. And then further, I think given the statements made by the defendant to Dr. McDonald, indicate that he would not be amenable to that specialized treatment if this court were to order something such as Chrome, which is an inpatient program that the state is aware of. And so given that, Your Honor, we feel as though there has not been a demonstrated or required downward departure guidelines. We also feel that even if this court were to find that those downward departure guidelines would have been met, we would request this court exercise its discretion and sentence the defendant to the guideline sentence of 65.325 months in the Department of Corrections, 3 years of which would be a mandatory minimum for that count one in the 25 CF 1985 case, Your Honor.
Yep.
Anything else?
Just briefly, Judge, I do agree with Mr. Snell with the 25 CF.
Mr. Gomez.
I apologize.
That's okay.
I apologize. The 25 CF 1985, count one, that is correct, the 3-year or the 36 months, that is the minimum today. I'd request that if this court does downward depart, that my client have 36-month with credit for all time served. He's been in custody. And if this court does agree with the downward departure, that he can seek treatment at Bridgeway under probation or be held so I can get acceptance to these other programs that Phoenix did convey to me that would accept my client with his criminal history. And of course, I just to let my client know, I submitted that whole evaluation into the record, and this court had the ability to review the full. I didn't have to read into the report. And so I respect.
And just to be clear too, I had the benefit of Mr. Powell's letter to me, which I've read as well. I don't know if you had the benefit, Mr. Gomez. Did you have that?
I think it may have been on quick.
But Judge, that would be my argument respectfully to the court.
And as you can see, I was quickly reviewing 921-0026 and also the cases which informed the court of how to exercise its findings under 921.0026. And as Mr. Powell says, I've had him a couple of different times, and the court has extended grace to him a couple of different times in these cases. You know, I don't have a cookie cutter approach or anything to sentencing. I take each one seriously, and I try to contemplate each case seriously. And we know that the 921.026 statute says that there's two things that have to happen for the court to depart. And the first is that there has to be a legal basis for the departure, and you've hung your hat on 2D, which is the defendant requires specialized treatment that's unrelated to substance abuse disorder, and physical disability doesn't count here. That's excluded from our consideration here, I believe, and the defendant is amenable to treatment. And then after the finding of whether it's legally permissible, then the court makes a determination of whether it's appropriate. And I use that word because a lot of the cases use that word appropriate, looking at the totality of the circumstances. After reading the report, after listening to the defense elocution, I can't make a determination that you've met the legal standard for a departure here based upon the report. So the defendant would be sentenced to the minimum guideline sentence, credit for all time served, and that's concurrent. And I believe there is a minimum mandatory sentence in the 25 case, correct?
correct, Your Honor.
1985, yes, that's correct, Judge. Count one. That's it. This is me as well.
All right, and fines, fees, and costs, Madam Clerk, were announced, I believe, in the plea agreement. That's correct. And we'll reduce those to a judgment unless Mr. Powell asks when he's released for time to pay them.
Yes, Judge.
That's one thing, Judge.
Yes, sir.
Ain't no way you could possibly consider suspending the sentence.
A suspended sentence is also a downward departure. The law's made that clear. And I got reversed on that too, so I know personally it's a departure. And so at this time, I can't do that, Mr. Powell, I'm sorry. Say again? Misdemeanor counts are, I think they're already timed out. I think all the misdemeanors are timed out, aren't they? Except on the new case.
Correct.
Time served on all the misdemeanor counts.
Thank you, Judge.
There you go.
Oh, you did. Thanks, Paul.
William McDaniel.